Association is very, very pleased now to present the third plenary on the most important topic of members of our profession who are at risk, often just for doing their jobs. Please welcome Vice President for Europe, Mr. Mark Stevens.
Thank you very much. We've got a real cornucopia of talent and experience with us with this morning's panel. As the autocrat's playbook for attacking lawyers and judges is spreading around the world like a contagion, a pandemic, if you will, it's not just across the Commonwealth, but also the wider world. As President Trump has indicated, he wants the USA to become an associate member of the Commonwealth. And I have to say, in my darker moments, I wonder if that isn't because the President wants to put a magnifying glass on some of the worst Commonwealth experiences and perhaps share his experiences of attacking law firms in America. I'll leave that rather dire thought with you. Now, many of you in the room have your own experiences, and so I've asked the panelists to keep their initial remarks short so that we can move to a wider discussion before we seek contributions from the floor. Three of our panelists have got direct experience, and Richard will speak of his personal experience and draw wider conclusions. Faith will speak from a more institutional perspective. Tony will talk about what he's been doing to roll back with new treaty legislation that he's been involved in drafting, and will explain how that will make a significant difference. And Keelan will talk about some of the cross-cutting themes. I'm then going to invite Professor Margaret Satterthwaite, the UN Rapporteur on the Independence of Judges and Lawyers, whom some of you will have seen yesterday morning at our keynote, to make an intervention from the floor. And then we will move to a wider conversation amongst the panelists so that we can drill down into some of the issues before I open it up to you to share your experiences. So, without further ado, can I invite Richard to come and start? Thank you.
How about that, Mark? Right on cue. Okay. Have we got a PowerPoint up? Or there we go. All right, thank you, Mark, and thank you, everybody, for this opportunity to speak. As much as anything, actually, I'm here to say thank you to the Commonwealth Law Association, or Lawyers Association, for the assistance that they gave me in 2022. Lesser thanks to Mark, because his idea of organizing a session like this is to sort of gather people up at drinks as they're passing and say, A, meet B, you're going to be on a panel together, it's going to be fantastic. And that's about the level of preparation we all got. But anyway, my role here is really to present, if you like, a personal perspective. I think it's quite important that we are able to drill down to personal experiences. And I want to describe mine, I think, not the best, not the worst, just a fairly typical sort of experience. I don't think there's anything particularly special about mine, and I think many lawyers around the world, including in the Commonwealth, suffer far worse outcomes than I have. But mine, I think, is fairly typical in countries that have become autocracies, and I'm actually pleased to say that Fiji is bucking the trend and actually returning to a more democratic rule of law situation. So that's the value I think that I can add. And often it is actually the banal, low-level harassment that wears you down as much as the high-profile stuff, although I have to say I tend to be more energized by that than the opposite. Okay, I'm a dumb old commercial lawyer, and I'm told I've got to do this in less than 2 billable units. Here we go. First of all, just to let you all know where Fiji is, in case you don't remember, there we are. I like this map because we're at the center of everything. In deference to my Pacific Island colleagues, we have Tonga just to the southeast and Samoa to the northeast. 900,000 people, so bigger than Malta. It's very rare that we can say we're bigger than anybody. There's our flag, I think, fourth on the second row, still with the Union Jack. And I think because you can read faster than I can speak, assuming that the clicker works, which it's not. Can somebody help us perhaps with the slides? Oh, there we go. Right. So because you can, let's hope it keeps coming.
Maybe we could have another clicker and or batteries.
Because you can read faster than I can speak, I think there's your Fiji refresher. We've had 4 coups since independence. We had one in 2009 when the military government abrogated the constitution because of a decision it didn't like. We weren't sure whether that was a coup or not, so we called that coup 4.5. But I think if you look at the bottom, the rule of former Prime Minister Bainimarama, fairly typical for autocracies these days, jailed his opponents for corruption, appointed a number of pliant judges, and I have to say, we ended up with a bench, both in the High Court and the Magistrates Court, that was 60% Sri Lankan. I don't want to diss the very good Sri Lankan lawyers I've met. I just have to say that certainly the Sri Lankan judges who were appointed in place of Fiji judges, who the military government did not like, and Australian and New Zealand court appeal judges, who the military government liked even less, were appointed for a particular reason. That said, and I'll come to that, there were some principled Sri Lankan judges who I think were probably appointed by accident. Otherwise, however, that's the pretty typical autocrat's playbook, isn't it? So my personal experience was it's in 2006, getting picked up by the military for what we tended to call the usual treatment, bit of low-level violence, threats, gunshots off against the head, being told not to do anything again. In 2007, our law firm was banned from doing any government work. Bear in mind that we are the biggest commercial law firm in the country, so we were banned from doing any government work. Our court filings and rulings tended to be delayed. So I think if you have an idea, notwithstanding the fact that as the largest law firm, it's 25 lawyers in Fiji, we were the mega firm, we spoke out against military coups, we acted for government opponents, we acted for political parties on matters of principle, news media, journalists, public servants who fell foul of the government, ordinary citizens. And my other senior partner, John Apted, and I tended to just say, well, what can we do? And it just became a standard. We'd walk into each other's offices with a particular problem, roll our eyes, it's got to be pro bono, what can we do? We don't really have a choice, we have to do it. So interestingly, being banned is the Perkins Coie experience. We watched to see which law firms would stand with us and which ones wouldn't. We're watching the US situation with interest at the moment. Been there, done that. And so that tended to be our experience, the ongoing lower level harassment, tax, professional conduct, exchange control, being examined, and so on. So this was then what happened in 2022. By this time I had a newspaper column criticizing the government. They didn't like me very much. And what do you do on a Saturday afternoon? You're reading your judgments, as we all do. And I came across this one, where a judge had managed to twice get the word injunction mistaken for injection. So my post was, if you can't read it, maybe our judges needed to be shielded from all this vaccination campaigning. I'm pretty sure all the applicant wanted was an injunction. So that's what happened in February. Didn't think anything more of it until July, as we were running up to an election, and it's speculated that I'm going to be an opponent of the government, and all of a sudden contempt proceedings are brought against me. Again, I won't waste a lot of time on that other than to say it was a Kafkaesque sort of experience. We made the New York Times. My partner, John, who you can see in the bottom left-hand corner there, acted for me. And basically we said, it's a race. If they can get me in jail before the election, they win. If we can hold out until after the election, we'll probably win. The Chief Justice went to one of the Sri Lankan judges and said, here is the file. I want him inside for 6 months. This actually has been deposed on affidavit. That particular judge said, well, I'm doing it on facts and law, at which point the brief was withdrawn and handed to a different judge who was a little bit more accommodating. As I said, it got more and more bizarre to the point where John, as my counsel, said to the judge, if you rule in that way, Judge, you would be little more than a kangaroo court. Well, that was fine, except that the judge did rule in that particular way, at which point the government said, well, the court's ruled that way, therefore Mr. Naidu's counsel is also in contempt of court by calling it a kangaroo court. So he was actually facing contempt proceedings. So the thing just got more and more bizarre. The only lucky break I got was when I was convicted of contempt, that my King's Counsel, the redoubtable Martin Daubney of Queensland, was on holidays and could not attend my sentencing, which meant that my sentencing was delayed until after the election. Fortunately, it's a close-run thing, but the election produced a new government, and we began the process finally. That's the picture of me looking happiest in the bottom right-hand corner when the proceedings were finally set aside. So the whole thing was bizarre. The fastest moving piece of litigation in Fiji court history, I think. But not quite fast enough to get me jailed. So it was a very close-run thing. All right, so very quickly, what are the lessons I've learned? Again, I don't think that there's anything here that is particularly new, but I think what's important is to note that autocrats are now more sensitive to their international reputations. So they're looking for softer and more subtle ways to deal with their opponents. It's not just a matter of chucking them into prison. If you can use the court process to put a veneer of legality on your attack, and I think this is something that, that Professor Satterthwaite talked about yesterday, that's what you're going to do. So solidarity and confrontation is important. I had 8 different law organizations, including the Commonwealth Lawyers Association. There they are. Speak up for me. And it was really important. Ironically, the media in Fiji could not publish any of those comments because to do so would mean they too were going to be up for contempt of court. So that sort of solidarity is important. Nothing beats an independent judiciary. Why do I say that? It's obvious, isn't it? But again, just from a personal experience, I have to say to you, nothing is more demoralizing than doing your research, preparing your submissions, as is usual, spending half the night up with your staff on the photocopier, getting your submissions ready, all to know that it's for naught, that the judgment that you're going to get, the ruling you're going to get, is you know what's coming, and you're going to lose. My next point, I think, is just about campaigns to support lawyers at risk. They've got to be planned and sustainable. I had the good fortune of the support of the Law Council of Australia and the redoubtable Marjorie Nichol, who pretty much directed the campaign in support of me like a military operation. But I think also to remember that organizations have also got to know when to hold back. In 2006, when I was picked up and dealt with a little bit more severely, a large international organization came out with a condemnatory statement very quickly. In fact, although I was fine, in a different situation, that could put the lawyer at further risk. So these things do have to be planned and managed a little bit more carefully than might first appear. And finally, one of the things that was slightly unnerving was that diplomatic representation and diplomats in courtrooms can be very effective. Just having the representative of a foreign government sitting in a courtroom observing proceedings can sometimes be quite unnerving for judges, even tame ones who have got their own international reputations to consider. In my particular case, geopolitics meant that by the time we got to my case, no government was prepared to put a diplomat into my courtroom, which I found a little bit concerning and demoralizing. But again, I think that's something where law societies and law bodies can put pressure on their governments and say, you know, come on, you people, get with the program. All right, last slide. As you know, spelling errors are my specialty. Michael Waltz, the infamous Michael Waltz, of course, caused a scandal by handing off his contacts to Atlantic Magazine. The other scandal, though, which I find just as outrageous, is that he couldn't spell principles. End of story. Thank you.
Thanks, Richard. Faith. I'm sort of loath to say that that was marvellous, but it kind of was. Faith, we look forward to hearing from a Kenyan perspective.
Good morning, everyone. It seems like we didn't have breakfast today. So lawyers serve as an essential guardian of justice and fundamental rights, yet face mounting risks in the noble profession. Allow me to quote Senior Counsel Feroz Noorji in his honor from his book, The Role of Lawyers. Our conscience dictates that we must protest against oppression, lawlessness, and the denial of the rule of law, that we must oppose it, and that we must attempt to alter it. These are the places in our profession. When faced with this type of governance, we must act as a profession expects us, as it instructs us, and as it inspires us. And so I'll be speaking about lawyers under siege and lawyers under risk, but from the perspective of the Law Society of Kenya. And from an institutional point of view, under our law, the Law Society of Kenya Act, under Section 4, allows the Law Society to give guidance in terms of the rule of law and protect the Constitution and the rule of law in our country, and also advise the executive with matters of rule of law. So hence, the kind of position the Law Society takes. So the evolving threat landscape, we look at state encroachments and legislative attacks. So they have been a trend in terms of trying to curtail bar associations' independence, restricting judicial access through harassment of lawyers, and imposing burdensome regulations on the legal practice, an attempt to limit the voices of advocates. And we've had this from individual lawyers that the Law Society has come to intervene or has had to intervene. First is malicious prosecution. One example I give was charges were levied by the Director of Public Prosecutions with regards to a peculiar case. Allow me to give you a short context. The new government in Kenya had since come into power, and there was a land dispute between an old man and the new deputy president of the country. and he was the only witness with regards to that matter. So the day that his matter was coming up, that he was supposed to, there was a hearing that was supposed to take place, and he was supposed to take the stand. So what happened? The night before, the plaintiffs are arrested and charged for fraud by the Director of Criminal Investigations. And of course, they call their lawyer. Their lawyer rushes to see them. And what happens? The lawyer is also arrested. And if it's not for the Law Society intervening and coming to court and impressing on the court that the aim of this prosecution was to, in event, frustrate the matter, that the civil matter that was currently ongoing, that the court now was impressed to end up issuing orders, and we had to go later to the Constitutional Court to stop the prosecution that was going on. And we've had several situations like that. We've seen also physical violence during the Gen Z protests in our country last year in June, where several advocates were physically attacked who were trying to access clients. We had to get court orders to access police stations. We had to get court orders to access clients. And worse off, even a council member of the Law Society, Irene Otto, was injured by a tear gas canister while at the police station trying to access clients who had been irregularly arrested and was hospitalized. So there is denial of audience also in courts, a rather peculiar instance where the judiciary, and apart from the judiciary, let me turn it first to denying access to courts with regards to the executive. We had a situation whereby, as advocates gave free pro bono services to represent protesters, we had police dressing as plainclothes to deny advocates access. So pulling people out of the courtroom so that as the victims would seek representation, there would be no one to represent them. And the Chief Justice ended up issuing a statement, but that was a first for our country, that we had never seen police officers posing as journalists and then stopping advocates from entering courts. Further is instances where the judiciary has been turning guns against advocates for personal differences to the extent of denying them audience in court. And I find it interesting, the first speaker was giving his experience, which some lawyers have since experienced, not being able to access different courts. A painful one for us is we forever commemorate the late Willie Kimani, a human rights advocate who was killed by police officers in the worst way possible. He was tortured and later killed and his body thrown because he was representing a victim of police brutality. Later on, 6 years later, the matter was hard determined and the police officers sentenced. But the reality is, if it's not for one witness standing and becoming a state witness, we would not have had evidence that would have changed the tide, because that matter we were losing. In terms of the entire police force were working cogently together to prevent that matter from being hard and determined. And curious now, a case that we're still dealing with is the Baby Pendo case, a case where a young baby who was in the arms of her mother was beaten up. The baby's head was battered and the baby died, of course. But today, the frustration that is still there for justice for that child, that even after years of ensuring this case lands in court, there's now frustration from the prosecution office for the witnesses to take the stand. And that just represents the challenge even of the Gen Z killings to date. No individual has been charged, irrespective of there being video evidence showing who these individuals were. But unfortunately, the tampering of evidence by the police, because we still rely on the police to carry out forensic review of evidence. And by virtue of that, a lot of victims know the perpetrators behind the killings of their children, yet there's nothing that can be done, irrespective of the promises the Law Society stands to just continue pushing as we demand for justice for those victims. Digital surveillance and cyber threats. As a law society, we do a lot of public interest litigation cases. And unfortunately, a lot of our members that have taken up high-profile cases have suffered through surveillance tools like Pegasus spyware, where their phones, their laptops are totally disabled, and they're not able to access their documentation and access their information because of information being retrieved, which are used to target the lawyer-client communications. The digital assault extends to database hacking of law firms and coordinated online smear campaigns against human rights lawyers, fundamentally threatening client confidentiality and professional independence. Several advocates at the Law Society have suffered risk to such surveillance, particularly during last year's protest. Several advocates who are at the front line have suffered the same, their phones tapped, communications intercepted, and physical locations pinned to enable police trail their movements, a challenge that will still suffer today. And what has since happened in the country, several cases have been filed, particularly against the major telcos in our country for sharing information of where individuals can be found. Public perception and undermining of the profession. Negative portrayal of lawyers has enabled systematic undermining of the profession through government interference with judicial independence, reduced public support through lawyer prosecution, and cuts to legal aid, limiting access to justice. Now, the Law Society of Kenya has continued to fight to defend its members. We join cases and seek to stop malicious prosecution against advocates. We assert independence from government control. The Law Society always gives an alternate voice, and sometimes we're called the opposition, particularly an interesting situation in our country that there's no actual opposition currently in our nation. Strengthening self-regulation to prevent interference, and we create defense funds for lawyers under threat through support of our various partners who continue to work with the Law Society. We have received threats and also attacks as a Law Society individually, and it's by collaboration and working with different organizations that we're able to still surmount a strong front. And I still thank the CLA and the East Africa Law Society that whenever the Law Society of Kenya has been under attack as an institution, they have always come to the aid and issued messages of solidarity. So I would like to leave in terms of us talking about solutions when we'll be having the panel discussions. But the aim was to just give an overview of some of the challenges that from an institutional point of view we continue to see. The Law Society continues to give strong statements in defense of independence of the judiciary and independence of the legal profession, highlighting illegal actions by the executive. However, the attacks are still systematic. And so even as we discuss and collaborate, the question is, how do we surmount the attacks? Because the government will always have greater funds than individual bar associations. But what can we do as collective associations to ensure that we remain independent, we still strive to protect the rule of law and ensure independence of the legal profession? Thank you.
That was marvelous. Thank you very much, Faith. And interesting, Tony, if you want to go on. There's a really strong role that the Law Society of Kenya is playing, and I think we're going to see that reflected in Tony Fisher's contribution from the Law Society of England and Wales and the work he's been doing in trying to help bars around with his new convention. So, Tony, over to you.
Thank you very much, and thank you to the CLA for inviting me to join this panel to discuss the new convention on the protection of lawyers. So you've heard the experience of two countries, but in recent years, as we all know, we've witnessed numerous threats to lawyers, including the sort of physical attacks, harassment, intimidation, and legal restrictions you've already heard about this morning. These threats erode the independence of the legal profession and compromise its ability to defend the rights and uphold the rule of law. Now we have a geopolitical storm in the background which has gathered momentum while the convention has been in the course of being drafted. The need for additional protections for lawyers is growing daily. And it may seem strange that prior to the new convention, there's never been a binding international instrument protecting lawyers' rights. We've recommendations from the Council of Europe, we've guiding principles from the UN, and a range of other instruments which have seen states across the world signing up and committing to protect many of the rights and freedoms which now appear in the convention, but none of them have ever been binding on the states concerned. There's been no supervisory mechanism to hold states to account if they violate the rights that they have promised to protect. It's long been recognized, however, that these protections are not enough to secure the ability of lawyers to carry out their professional duties independently and without fear of interference. There's never been an effective mechanism which provides that protection. The journey towards the convention began in September 2016 with a letter from the Council of Bars of Europe to the Secretary General of the Council of Europe, and since then there have been several key milestones before the adoption of the convention by the Committee of Ministers on the 12th of March this year. It's a significant step forward in the international recognition of the fundamental role that lawyers play in society. We are at the sharp end of trying to secure respect for the rule of law. The primary purpose of the convention is to protect lawyers against attacks, threats, acts of intimidation of the sort that you've heard about this morning. It aims to guarantee their independence and professional autonomy, safeguarding and strengthening the profession's essential role in upholding justice, the rule of law, and human rights. After a mandate was granted by the Committee of Ministers in November 2021, a new committee was formed, tasked with the creation of a new instrument concerning the rights of lawyers. The committee, known as the CJAV, or the Committee of Experts for the Protection of Lawyers, was formed in early 22, and it met for the first time in April 22. So over a course of 9 three-day meetings, the treaty eventually took form, and it was finalized in September last year. I was appointed as the UK representative on the CJAV, and as an independent lawyer in private practice, I was in the minority on the committee, since most states which were represented appointed lawyers from their own ministries of justice. However, the presence of a handful of independent lawyers had a profound impact on the drafting process, since we were the only members who had personal experience of the sorts of persecution which lawyers have suffered in their own countries within the Council of Europe. It wasn't an easy process, as you can imagine, navigating through the complexities and varying practices and rules about the establishment and membership of bar associations in so many jurisdictions with a different historical perspective on the various rights and practices concerned was always going to be difficult. But as time went on, the work of the committee became more collaborative, and we set to the task, as lawyers always do, with infinite attention to detail. And by the last meeting, we were literally crossing the T's, dotting the I's, and arguing about the he's and she's and theirs. It was an exhilarating process to be involved with, and we all felt a profound sense of duty to get it right. Whether we did will be judged by others, but very little amendment to the text was made by the Committee of Ministers, and it's hopefully going to be opened for ratification by state parties at their next meeting on the 13th to 14th of May in Luxembourg. At least 8 countries need to sign up in order for it to come into effect, and we're very hopeful that that will happen in May. So you might ask, why does a binding instrument matter? Well, it's crucial because it establishes legally enforceable standards that countries are obliged to uphold when they sign up to the convention. It includes a monitoring mechanism to ensure compliance and accountability, providing a practical way of monitoring compliance with the rights protected by the convention. The key principles of the Convention have been comprehensively summarized in recent publications of the Council of Bars of Europe, so I'll cover them very briefly here. Firstly, it seeks to establish the independence and autonomy of professional associations, such as bars and law societies, ensuring they can effectively promote the interests of lawyers and the public while upholding professional standards of conduct. States will be committing to allow professional associations to act independently without state interference, a problem in quite a few Council of Europe countries at present, and of course in many other states throughout the world. Secondly, states will be committing to ensure that lawyers will be able to provide legal advice, assistance and representation, including defending human rights, with freedom to accept, refuse or terminate client relationships. They will have the right to prompt access to clients, including those deprived of their liberty, and effective access to relevant case files and other materials held by public authorities and courts. The provisions are flexible enough to allow individual states to have rules for which, for instance, oblige lawyers in certain states to take on instructions where the principles of access to justice require them to. The cab rank rule in the UK is an example of one such rule. This requires barristers to take on cases in what is effectively a rota basis, except for in certain defined circumstances. Thirdly, the Convention safeguards the confidentiality of lawyer-client communications, enabling individuals to seek legal advice and representation without fear of exposure or retribution. Fourthly, lawyers will be protected from unlawful actions, such as the sort of assaults, threats, harassment, intimidation, or unjust disciplinary proceedings you've heard about this morning. It seeks to ensure that lawyers are not penalized for representing individuals or causes that may be controversial or politically sensitive. And that's a particularly sensitive area in some Council of Europe states, where lawyers have been seen to be identified with the causes of their clients and penalized as a result, whether by malicious harassment in the media, inappropriate prosecutions, sometimes threats of violence or actual violence by security forces. Another area which is addressed by the Convention is the question of access to the profession. For states who sign up for it, the rules concerning the admission, continued practice, and readmission to the legal profession will have to be based on objective, relevant, and transparent criteria without discrimination. Decisions on admission will have to be taken by an independent body and be subject to an appeal to an independent court or tribunal. The same is true for disciplinary procedures. One of the most difficult debates which the committee engaged in was the question of what the definition of a lawyer should actually be, since only lawyers as defined will have the benefit of the protection of the Convention. Around the 45 countries in the Council of Europe, there are, of course, so many professional titles of those individuals who, in some way, engage in the provision of legal services. In some states, and the UK is certainly one of them, there are a host of independent regulators which have separate rules and regulations for their own particular members, whether they are solicitors, barristers, licensed property conveyors, notaries, or even, in the UK, accountants who are authorized to undertake work in relation to the estates of people who have passed away. All could conceivably come under the description of lawyer, and this would create a great deal of uncertainty with regard to the application of the Convention. In the end, we settled on the same approach as adopted by the European Union in the professional practice regulations. States will have to identify the professional titles of lawyers within their own jurisdiction who will have the protection of the Convention at the time they adopt it. And there are mechanisms to prevent that procedure from being abused. Finally, I'd like to say a few words about the enforcement of the rights protected by the Convention. First, it's important to stress there will be no new European court to enforce these rights. There is no political appetite, and there is certainly not any money to duplicate the role of the existing court. Lawyers' rights, which are already protected under the ECHR, will continue to be so, and their remedy of being able to petition the court in Strasbourg will remain, subject to the usual rules which require exhaustion of all domestic remedies before such an application is made. The Convention will, however, have a supervisory mechanism which is similar to a number of other European conventions. Complaints will initially be made to a committee of experts, which will be appointed after the convention has been adopted by at least 8 states. It will make its own rules of procedure, and it will also carry out its own periodic evaluations of those countries which have adopted the convention. Complaints will be taken from professional associations, lawyers' associations, and possibly civil society NGOs who have the function of trying to protect lawyers at risk. A committee of experts will investigate any complaints made and provide a written opinion identifying in its own view whether a violation of the rights under the convention has taken place. In addition to that committee, a committee of the parties will be formed, including representatives from all of the states which have actually ratified the convention. Its job will be to consider the opinions of the committee of experts and exert peer pressure on other countries who are in violation to put the situation right. It's a very similar situation in a number of other European conventions. Perhaps most importantly in this context, although the convention is an instrument of the Council of Europe, it has broader implications beyond Europe. Non-European states, which would include all Commonwealth states, can sign and adopt the convention, improving access to justice for citizens and lawyers in their own jurisdictions. So there we have it in brief. The drafting of the convention itself was purposefully concise, and broader guidance is given in a longer memorandum, explanatory memorandum with regard to the interpretation of its provisions. It is a revolutionary international instrument, and there is a real hope that it will make a positive, practical difference. The world is changing. Even over the period of the convention drafting period, the need for this convention has become more pressing. Countries where it's never been felt that such protections were necessary have changed. The UK is a good example. In the summer of 2024, a substantial group of immigration lawyers were subject to abusive and threatening behaviour. The Law Society and the Bar were quick to intervene, and so was the government, to bring this to an end. But across the pond in the US, we have seen unprecedented pressure put on lawyers over the course of the last few months to withdraw from civil rights litigation, which is felt to be uncomfortable by the new administration. Across Europe, in an increasing number of Council of Europe countries, similar pressure has been brought to bear. The time for this convention is now, and I hope sufficient states ratify it in May so that it comes into effect at the earliest possible opportunity. So whether you come from a Council of Europe country or not, you have a chance to make a difference by lobbying your own government to adopt the convention. It shouldn't be forgotten that the genesis of the convention was a letter from a lawyers' organisation, the CCBE. Bar associations and lawyers' associations in any Commonwealth country could do the same. The opportunity is available now. So thank you for listening, and I hope to be able to answer any other questions later.
Thank you very much, Tony. It's really wonderful and heartening to hear people of good heart like you who've really taken on this challenge, and I look forward to discussing more about that as we go through. Now I invite Keelan Gallagher, KC, from Doughty Street Chambers in London, who has personal experience, but I've asked Keelan to focus on the cross-cutting themes of this, and afterwards I'm going to go to, as I said, Professor Margaret Satterthwaite. So, Keelan, off to you.
Thank you very much, Mark. Esteemed Excellencies, Judges, Attorneys General, colleagues, we're here today in the most beautiful of settings, of course, overlooking the bright, clear waters of the Mediterranean Sea, a short distance from the honey-coloured limestone streets of Valletta, a UNESCO World Heritage Site. But I want to begin my remarks with reference to the most ugly of things, the brutal assassination of a journalist here in Malta on the 16th of October 2017, 7.5 years ago, the assassination in a car bomb of Daphne Caruana Galizia. I've had the privilege of getting to know Daphne over the past 7.5 years through her incredible family, who I'm proud to represent. And I've got to know her through reading her brave investigative reporting, her searing, no-nonsense, vital writing, uncovering corruption, putting her head above the parapet when others did not. She was a courageous woman and a brilliant journalist who used her skills to speak truth to power and knew the importance and value of her profession to democracy and to the rule of law. I also, of course, learn about Daphne from reviewing the 3 decades of threats she received simply for doing her job, including arson attacks on her home, attempts to cut off her income, the freezing of her bank accounts, dozens of libel suits brought by ministers and business people, vile misogynistic attacks online, critics in the street calling her a witch. It feels like they're trying to fry me alive, she told her son Matthew. He later testified. In many ways, what happened in October 2017 in this place was a logical, horrific extension of the many other ways the powerful had attempted to silence Daphne, the ultimate form of censorship. That's why I wanted to begin by having this image on screen, which is from one of The Economist's most popular images in the year after Daphne's death in 2018. It's a photograph of graffiti sprayed on a wall here in Malta in Mesida with the date of her assassination. Speak the truth, even if your voice shakes. Something Daphne did every day in her profession as a journalist, despite the risks. And a motto I say we must bear in mind as lawyers, committed to discharging our duties to our clients without fear or favour, an essential cornerstone of the rule of law. Now, increasingly, as journalists face complex and intense legal attacks designed to silence them, what my client, Nobel Peace Prize-winning journalist Maria Ressa in the Philippines describes as lawfare, lawyers play a critical role in safeguarding free and independent media. And as a result, lawyers themselves are increasingly becoming the targets of a wide range of attacks that seek to undermine these efforts. Some of my focus here is in relation to lawyers acting for journalists, but of course, these trends which have been identified apply in a much wider range of areas. Now, attacks upon lawyers for journalists have been detailed in a recent report by the American Bar Association, the Thomson Reuters Foundation, and Media Defense called Defending the Defenders. And it identified 4 trends of targeting lawyers acting for journalists, which apply equally to lawyers acting for human rights defenders and a range of others. Threat 1, disabling lawyers through criminal suits, frequently brought shortly after a lawyer takes on the representation of a journalist. And the legal weapons vary that are wielded: anti-terrorism laws, bribery or corruption laws, even false news laws. But the aim is always the same, which is to undermine the lawyer's ability to represent their client. And in addition to the negative impact on a lawyer's reputation, those criminal suits often are accompanied by years-long detention and fines, disincentivizing lawyers' professional activity in this field. Threat 2, interference with lawyers' ability to represent their clients through things like seizure of property, including case files, prevention of private meetings with clients, contempt charges taken for actions in the course of representing clients. Another example, Jose Ruben Zamora, my client, a journalist in Guatemala, has been represented by 9 different legal teams during proceedings because of attacks routinely on his legal teams. And also with the proliferation of technology, the analysis in this report identified several cases where spyware and cyber attacks were used against lawyers in order to obtain confidential information concerning their clients. Threat 3, targeting lawyers' ability to practice their profession. This is something which we increasingly are seeing in a range of countries worldwide. This particular report focused on lawyers acting for journalists. It's also a trend that we've seen for lawyers acting for environmental clients in the US, for example. That is the targeting of lawyers' ability to practice their profession through arbitrary disbarment, arbitrary suspension of license to practice law, misuse of bar disciplinary proceedings, all designed to have a chilling effect on the lawyer doing their job. Threat 4, physical threats. In some jurisdictions, lawyers face threats to their lives and safety due to their representation of journalists, this report found. And it highlighted several instances of lawyers being physically attacked due to their work, receiving death threats, surviving assassination attempts, or being harassed and intimidated, often in a climate of total impunity. And for those of you who haven't read it, Maria Ressa's Nobel Peace Prize lecture in 2021 highlighted the very close relationship between targeting of journalists and targeting of their lawyers. And she identified then 22 journalists who had been killed in the Philippines since Duterte came to power. And during that same time period, at least 63 lawyers. So it's a trend which she highlighted. Now, today I want to highlight a cluster of additional risks to lawyers which are usually overlooked concerning transnational cross-border risks. Increasingly, in my work as a human rights lawyer over the past 25 years, I've seen a trend of states no longer being content to simply target critical voices within their own jurisdictions, but instead using the long arm of the state to try to target their critics wherever in the world they may be. We, of course, now live in a world in which Saudi Arabia orders the dismembering of a Washington Post journalist in Turkey. Russia poisons its critics in London and Salisbury. Journalists can be forcibly brought within jurisdiction, as Belarus did, by hijacking a Ryanair plane, in which an Iran international journalist in London, Pouria Zarati, a client of mine and Mark's, was stabbed in broad daylight in London on Good Friday last year by hitmen who'd flown into Heathrow Airport specifically for this purpose and left from Heathrow Airport within hours. Now, the 5 tactics I've tended to see in transnational repression against my clients over the years are the following. Number 1, direct targeted physical attacks, so assassination attempts, physical attacks, rendition. And number 2, online and remote threats, cyber harassment. Number 3, mobility impediments, so travel bans, cancelling passports. And number 4, co-opting other states, so misuse of Interpol red notices, for example. And number 5, proxy targeting, so targeting family members in order to try to stop the individual exercising their profession or speaking out. Now, those tactics and methodologies differ, but the aim is always the same: to target those who speak truth to power or challenge the powerful, to frighten, to censor, to silence. And we are now seeing those tactics, which I've seen in my work over the past 25 years, being used against international lawyers for representing their clients. And this is a key aspect of the evolving threat landscape, to use that phrase that Faith referred to in her speech. And I am now, in fact, experiencing these tactics myself. Now, for many years, I've been targeted in a secondary way. It's simply routine. If you bring a case against the Kingdom of Saudi Arabia, against Iran, against Egypt, it's quite typical to find, for example, that you or members of your legal team have attempts to hack your email, by way of example, because the aim there is you as the lawyer are a secondary target. It's simply designed to access confidential information about your clients. And indeed, in the Malta case in which I was acting, I had the rather unique experience for an Irish person of being called a neo-colonialist, which was rather interesting. But with one current case, what I now experience is a little different, and I just want to highlight it in brief here. And that relates to actions by the Chinese and Hong Kong authorities due to me representing the journalist, the British national Jimmy Lai, who's imprisoned arbitrarily in Hong Kong. And I say he's imprisoned arbitrarily because the UN Working Group on Arbitrary Detention has made that finding in recent months. There's a range of methods used to try to stop me doing my job as an international lawyer. It includes state media describing me as an enemy of the people, a notorious anti-China element, threats to prosecute me and my colleagues and Jimmy Lai's son for bringing claims before the United Nations bodies, sophisticated hacking attempts, so of my email, document management systems, also personal bank accounts, online threats, much of it misogynistic and gendered, and very frightening. So you wake up on a day of a key day in the case. I'll often wake up to a rape threat, for example, including very recently a rape threat for my 16-year-old daughter. Also to multiple attempts to hack your different accounts and multiple attempts, multiple cyber threats. And that all happens, it's not a coincidence, 5 or 6 a.m. on the day of a key case. It's like whack-a-mole, really. And it's designed to be attritional. It's designed to make it more difficult for you to do your job, more difficult for you to do ultimately what we all need to do as lawyers, represent our clients effectively. And I've also seen a new tactic of privilege phishing designed to access sensitive information, which I'm happy to talk about further later if people are interested. I'm acutely conscious of my privilege making reference to this. I am not a Hong Konger. I do not have family members in Hong Kong or in mainland China. I'm a Western, privileged, middle-class white woman, so I have much privilege, and it's why when we were asked if we would speak out about our experience by the UN Secretary-General's team, we agreed to do so. And we're grateful to the UN Secretary-General for highlighting this case in the 2023 and 2024 reports to the UN General Assembly as a reprisal against me and my colleagues, but also, most importantly, against our client. And we're also grateful to the countries which have supported us at UN level, many of which are Commonwealth members, the UK, Canada, Australia, New Zealand, and also indeed the US. We're also grateful to the professional bodies, the Bar Council of England and Wales, and the International Bar Association Human Rights Institute, which has spoken out. Conscious of time, but I just want to make a couple of quick points about what we can now do. This is a real threat to the rule of law globally, and transnational repression of lawyers raises very particular concerns because we're left to tackle transnational repression using domestic criminal laws and electronic tools which are creaking to keep up. And I suggest there are 4 things which we in this audience and in this room can do. The first and most basic is when acting in sensitive cases, when there's a risk of surveillance or hacking, good security hygiene is critical. Often lawyers are the weak points for activists and journalists. I've lost count of the number of cases over the years when I'm asked to act in a case against Saudi Arabia, Iran, or China, where lawyers will send Google Docs or conduct sensitive discussions over open email without good security hygiene, which is a risk to you as a lawyer, but most importantly, it's a risk to your client. So that's the first point. Second, I never thought to this esteemed audience I would quote Vanilla Ice, but here we go. I recommend that we stop, collaborate, and listen, because overall, across the board, we need to talk more. We need to understand the techniques that are being used. We need to pool resources. It's often very frightening when these things happen to speak out. It's designed to be intimidating. People deal with it in their bedrooms when you receive rape threats at 5 in the morning, and they're frightening, and you might feel embarrassed to speak out about it. But we've got to start talking about it. It's key for us to talk about it here. It's key for states to talk about it. And it's key for lawyers to understand the tactics being used, what to watch out for, and discuss amongst ourselves when we can, like in rooms like this, so we can provide better service to our clients. Number 3, we need to get creative about targeting the bag carriers who facilitate this kind of action. For example, with spyware, I'm pleased to see action being taken against an Irish-based company which was sanctioned by the Biden administration last year, which was used to target many of my clients. And 4th, above all, we must speak out and support those affected. When governments and leaders undermine the rule of law, we must call it out. We must hold states to account when they either target lawyers or allow lawyers to be targeted with impunity. Representative bodies should provide support, and when barristers who've written a report about the Uyghurs are sanctioned by China, as happened in the case of Essex Court, we must provide robust statements and support. And I'm not only talking about states such as Russia, Iran, Egypt, China. When politicians in the UK describe in denigrating terms activist left-wing human rights lawyers, we must call it out. And ultimately what I would say is we must speak the truth, even if our voice shakes. We must be more Daphne. Thank you.
Thank you very much for that, Keelan. Can we have some lights up over here so that Professor Satterthwaite can speak? I think one of the things that you spoke to very powerfully there was the loneliness and also the nationality of some of the issues. And I think one of the lessons that we're learning here, particularly from Richard and other speakers, is how perhaps with reaching beyond the state level, beyond the nation level, is going to help us. So, Professor Margaret Satterthwaite, can I just invite you to, and some lights please, so that we can see Margaret, and to say some things about what you think is going on and what resonates.
Yes, okay. So good morning. I don't want to take a lot of time because you all heard me yesterday, but what I would very much like to do is to congratulate and commend each of the speakers for the important messages that you brought today. Yeah. And I'd like to note very that very bravely each of you spoke about not only yourselves, and indeed very briefly about yourselves, but mostly about your clients and about the other attorneys that you work with. And I think that really demonstrates why we need to support and ensure the safety of lawyers. Lawyers are on the front lines, as we know. They call out injustice. That is our job. It is our job to stand up and defend our clients, and also to call out injustice when it is institutionalized. And I think the examples given today of how that institutionalized injustice is then weaponized against lawyers is very instructive. I'd also like to commend and congratulate again the CCBE and the CJAV for the incredible work on the convention. And I think we've been really, we need to be proud of that work, and I think we all have work to do now within our own countries to convince them to ratify. And I think, as Tony Fisher explained, any state can ratify this convention. And so I think we should make it an official goal that all of the member states of the Commonwealth do ratify this convention, and that we make sure that it's then taken up very broadly. I also want to say that my mandate is prepared to work on these cases, and I very much hope to have close relationships with all of the bar associations represented here, and look forward to those discussions. So again, a real commendation to each of you, and to just say that lawyers should not have to be heroes. And as you could see from the comments, lawyers often shrink from that kind of labeling and seek instead to bring forward the stories and the narratives of their own clients, right? Because that is our work. But we really do need to recognize that folks are heroes standing up against really institutionalized violence, harassment, and denigration. So thank you so much.
Thank you, Margaret. I think it would be useful perhaps just to ask perhaps Keelan to reflect for a moment on how some of you might operationalize Margaret's and the other UN mechanisms. So do you want to say a few words about that?
Of course, and thank you very much to the Special Rapporteur and to her team for all the work that they've done in this space, which is so vital. And I would say that the UN Human Rights Council special procedures mechanisms are underused by many of us, and you do not have to have exhausted domestic remedies in the country in question before going to them. And the UN Special Rapporteur on Independence of Judges and Lawyers, if you look at the range of cases that she's commented on and worked on since taking up her mandate, you get a sense of just how broad-ranging and deep her work is. It's a very simple process to make a complaint. There's a form which you can use online on the United Nations Human Rights Council Special Procedures website. It doesn't require particular specialist knowledge, and I can say from experience that the Special Rapporteur and her team are very sensitive and supportive, and are also very open to receiving information. For example, although I dread to use this word given recent news events, they are sensitive to receiving information over Signal, for example, if appropriate, if there's a concern about providing information over open email. And as well as the Special Rapporteur mechanism, the other examples, of course, this Special Rapporteur mechanism, if the case involves, for example, a journalist, you could complain to the UN Special Rapporteur on Independence of Judges and Lawyers, and also the Special Rapporteur on Freedom of Expression, for example. If it's a case which involves protest, where your client is a protester, you may want to go to this mandate, but also to the Special Rapporteur on Peaceful Assembly, for example. And the other mechanism which is very important to highlight is the reprisals mechanisms, both at the United Nations in Geneva and the United Nations in New York, and they can provide physical support. So one of the issues which I and a number of my colleagues had in the Jimmy Lai case was being physically followed and subjected to surveillance around the UN building in Geneva itself. We had excellent support from UN security. and from the UN reprisals team. Really practical support, which was helpful. And it meant, for example, when we were next speaking and addressing the Council, there was someone from the reprisals team physically there. They'd made special arrangements with security. They gave us advice on hotels not to stay in Geneva, for example. So I really would recommend, for those of you who do international work, it's worth looking at those options. And for those of you who are experiencing the kind of problems we've heard about on this panel, do think about making a complaint to the UN Special Rapporteur on independence of judges and lawyers, with apologies for your increasing workload.
Thank you. I'm going to ask Tony and Faith about how institutionally they think that this might be co-opted, these UN mechanisms to help them. But just before we get to you two, Richard, do you want to say a word about, you highlighted it, the fact that you were essentially the poster child internationally. How does that, tell us a bit about your practical experience with that.
Yeah, there we go. I was. I think, as I said, it depends very much on the environment that you're in. In some ways, having a higher profile as a dissident or a dissident lawyer in a country like Fiji, which not as brutal. I mean, I want to say this. Yes, I experienced some low-level violence, harassment, detention, all of those things. But I was saying to Faith that I don't think that the experience that I had is the same sort of brutal, violent experience that other lawyers have had. And so you have to put it all in perspective. But for countries, and I think it's really important to remember this, there's countries that are kind of beyond the pale. They're going to do to lawyers what they're going to do without being concerned about their reputation. Fiji's previous government had a reputation management company, Corvus, which some of us may know, also acted for Saudi Arabia and Bahrain, so that was not a good start. But there are countries, I think, which do value or pay attention to their international reputations, and that's when solidarity and speaking up does become important. As a pretty well-known dissident in Fiji, in one sense, I was better protected than people who are less well-known, because people would do less, or the authorities would do less to me, concerned about the international consequences of that. And so that was, in a weird way, a privilege that I had, which other people did not. So where I guess I'm going is that in those marginal hybrid countries, it is actually really important to speak up, because you can actually influence outcomes, including in many very small countries and autocratic countries, where you actually can influence outcomes. So I guess that's...
Yeah, thanks. Faith, do you think there's a space for Law Society of Kenya or East African law societies generally, more broadly, to start routinely operationalizing these UN mechanisms for not only their own members, I think they only go one at a time, for their own members, or indeed judges who are being persecuted?
I would say yes. We have had to reach out to the Special Rapporteur on Independence of the Judiciary. In the beginning of 2014, the Law Society of Kenya had nationwide protests with regard to the head of state making comments against judges that were making a decision. And the High Court had ruled against the executive, and the matter was now before the Court of Appeal. And the executive made comments directly hitting against the judges that were hearing that matter, and we engaged in nationwide protest, which sparked the interest of the Special Rapporteur, and we were able to meet with them, and they were able to apply pressure for the national government to step back. And we've had to do so with regards to peaceful protests, with regards to individuals that have not had justice to date in our country. And so the role of calling for for international intervention is quite important, because putting that pressure, because as the Law Society, we also met with different diplomatic envoys, and that pressure aided them reaching out to their national governments to put some pressure on our government, particularly when, one of our colleagues here has mentioned use of AML to pressure. One of the organizations used quite well in our country is the Revenue Authority, to clamp down and try and attach all your accounts so that you cannot engage in any exercise that is to the defense of human rights. And that was what was done with regards to human rights organizations and attempted at the Law Society as well. And so putting pressure through the diplomatic envoys as well as the international organizations really helped to bring down the pressure that was quite high to the different institutions that were trying to fight for human rights in the country.
Thank you, Faith. Tony, obviously there's a role amongst law societies in calling out wrongdoing by governments in other countries, because sometimes, it'll be inappropriate or difficult for Faith or other people in the audience to call out. Is there a role for the Law Society of England and Wales, the CCBE, the IBA, and perhaps most significantly here today, the Commonwealth Lawyers?
Yes, well, there certainly is a role, I think, and I mean, the Law Society does have a fairly well-developed program for attempting to protect lawyers at risk, which does include us having had the privilege of working with Margaret on a number of occasions on behalf of lawyers in a number of different countries. We've also, as Keelan has said, the complaints mechanisms under the treaty bodies of the UN are very underused. And we have in the past provided training for lawyers, particularly in Turkey, to help them to make complaints under those procedures. We also collaborate with other bar associations in making joint statements, making interventions, very recently in terms of the pressures which have been put on US lawyers. But we have an intervention tracker of lawyers that we've intervened on behalf of all over the world that's published on an annual basis. And we also...
Where can colleagues find that intervention tracker?
It's on the Law Society website, along with all of the other information concerning the Lawyers at Risk programme. And we also do some amicus briefs in cases where lawyers are being prosecuted, and recently did a collaborative third-party intervention in a European court case involving some lawyers in Turkey. One thing to remember, though, is that lawyers don't always want to have an intervention on their behalf, so we have to be very sensitive about that. They're sometimes in such sensitive positions where they, for instance, have members of their families still in the country that they are exiled from, which mean that they are very cautious about raising their own profile, because it may lead to attacks on their relatives. So we do have to recognize that. I'm also hopeful that with the new convention, there will be a way of coordinating these interventions amongst all of the bar associations, which is given more publicity on a wider platform, because it will be surrounding a new binding international instrument which is specifically focused on the rights of lawyers and protecting them from the kind of abuses that we've heard about today.
Thank you, Tony. I'm going to come to the audience next, and so if you'd like to indicate, there are 3 people at the back, so if you put your hand up, one of them will come to each of you, and then we'll take your comments and interventions. But there was one other issue. Please show if you want to speak. One of the things that I also wanted to raise was the issue of sanctions, which was raised by the Deputy Chief Justice of Hong Kong yesterday, but is not isolated there. We've also seen threats from Trump and others, and we've also seen sanctions of English lawyers. by foreign states. So I do think there's a real issue here, and that's likely to be growing. And I think we need to think about how, as an organization and as people working together, we can stop that form of very basic economic intervention. So perhaps we could have some of the lights up a little bit. And who's got some comments here? There's one there I can see. Any other hands up? Thank you.
Brian Spears, past president of the Commonwealth Lawyers Association from Northern Ireland. I must say I was in part distressed, in part inspired, and in part humbled by the excellent contributions from the panel. And I wanted to share, as you will know, Mark, that the CLA have issued statements in support where appropriate. I feel we should do more about that, and it's very gratifying to know that those statements can sometimes help, even just to let people who are targeted to know that they are being supported. We also, 2 years ago, at the Goa conference of the CLC, did promulgate a Goa Declaration on the independence of the legal profession and the judiciary. And it does seem to me, and I would welcome comments from the panel, that international organizations should play a greater part from their position of both the cohesion that they have from many jurisdictions to support the type of appalling incidents that we're hearing that lead to this diminution of the rule of law. So the CLA, I think, will take away greatly from this, and thank the panel very much for their contributions to shine a light on this most important topic. Thank you.
Thank you very much, Brian. Yeah, go ahead, Tony.
Just on that subject, we did attend a meeting yesterday with David Green and the CLA Human Rights and Rule of Law Committee, and discussed future collaboration so that the CLA could be drawn more into the collaborative statements which are issued by the Law Society, the IBA, the CCBE, etc. So we're hoping to work more closely going forward from this conference as a result of that.
If I could just add something, Brian, thank you very much for what you said. And I'm acutely conscious, of course, that it took until September last year for there to be an inquiry, a public inquiry into the death of Pat Finucane. And Northern Ireland has, of course, seen a whole range of attacks on lawyers over many years. I think the point that you made about the CLA potentially doing more is very good to hear. I would not underestimate the value of solidarity. I don't know if others on the panel would feel similarly, but it can be a very lonely experience when people are being attacked in this way. This is something which my clients who are lawyers often describe too. And actually knowing that you have, when you've got powerful enemies against you, it's quite useful to know that you've got powerful people in your corner and powerful allies. So I think solidarity is hugely important, and I do think we should be faster at that. Over many years, I've acted for a number of lawyers in Iran and in Egypt who've been targeted, and it's been quite disappointing how difficult it's been to get international attention or international support for them. And of course, it's very fact specific. As you said, in some cases, you may not want to shout from the rooftops, but often they do. And often shouting from the rooftops does lead to a protective effect, makes it less likely that some of the worst excesses will in fact happen. And I, in my speech, referred to Daphne Caruana Galizia. It's worth saying 10 days before Daphne's death, she gave an interview to the Council of Europe where she laid out in very stark detail precisely what she was going through. And I'm afraid there wasn't enough international solidarity for what she was going through in time. And there then was an outpouring of support after her death. I think all too often we don't take action early enough in a preventative way. So solidarity and preventative support are both vitally important, and I'd love to work with the CLA on doing more on that.
I think it's important to talk about it. Tony, you made the very good point about when a crisis occurs, often sensitivity at that time precludes any advocacy either by that lawyer or in country. But I think often these things titrate up, and we see the increase in denigration, which is usually where it starts, and then up to more salient threats. And perhaps putting people into the public domain earlier would also chill some of the adverse behaviors. Richard, how did it happen to you? How did you become well known? You adverted to Marjorie Nicholl of the Law Council of Australia. Do you want to say something more about that?
Yeah, I just did want to talk about that solidarity point because it has come up. And I think in my case, 8 different organizations spoke up for me very quickly. And I can see people in the room here who were critical in delivering those things. Again, tactically, to speak as practically as we could, as we can, it's not just about being principled, it is about being tactical. And I think what I had in my corner was somebody from a neighboring jurisdiction, from Australia, understood how things worked, was in contact with me. Can we say this? Can we do this? Is it appropriate? Is it going to work? And it may or may not have worked. We'll never know. But as I said, oddly enough, none of the condemnatory statements of the court in Fiji could be actually run locally because the media organizations themselves, 2 of which we advised, we had to say, don't run the statements about Naidu because you'll only end up in court yourself. And maybe we'll have to act for you. But so
it's one way of drumming up business.
Yeah, so the tactics are important, I think, and having a neighboring bar association or friends who can say, right, we've got the contacts, we can make this work. And personally, I have to say, it was fantastic to have that kind of support. And in the end, the point has been made before, you do feel very alone and vulnerable, and having that support is really important. So thank you to everybody in this room, some of whom I can see, who were instrumental in supporting me.
I just want to jump in on that and now that I agree totally that the solidarity really aids a lot because without that voice to amplify, then you're not able to stop an impending action that actually can happen. The president of the East African Law Society gave an analogy. South Sudan's BAU could not issue a statement by virtue of the political position of how their government is. And the chair could not issue a statement after threats by the government that were going to shut down the internet to prevent any nuances or noise on what was going on in the country. And by issuance of a statement by the regional bar, they were able to stop, and the government changed its position because now it was being highlighted in the region, and now people were asking questions. We've seen in the region certain bar presidents having to cross the border to seek for asylum, even to our country. And right now, the unfortunate thing is our country is not as safe as it used to be. And so by highlighting and having more collaborations with CLA, I would say that we benefited during the worst time of what was happening in our country last year because one of the CLA council members comes from our country. And so every time we raised alarm, we always got the solidarity message. But I say that CLA needs to see how to seamlessly work with all its partners in the region because sometimes, yes, I agree that they may not want you to highlight a certain situation before they're able to evacuate a sensitive member that may be harmed. But certain times, the noise helps save someone's life. Because I remember there was one abduction that was being carried out, but because of the hue and cry that was raised in the local media and then later on within the same day in the international media and by different bars, we stopped the attempted abduction. And so I totally agree that there needs to be better coordination, that we can raise voices and prevent unnecessary death of advocates.
Thanks for that, Faith. I think that's a really helpful intervention. I'd like to talk a bit about, Keelan, this issue of privilege fishing, which you adverted to. Perhaps you could talk a bit about this, and if there are people in the audience who want to contribute, please do indicate. But obviously, we're acutely aware that some of these issues are sensitive, and you may want to talk to us privately and then confidentially, and that is also possible.
Thanks very much. So, of course, impersonating a lawyer is a crime across the world for very good reason. And part of the reason for that, of course, is that a lawyer is a trusted professional. You may give information to a lawyer which is very sensitive, may put others at risk, and it's, of course, privileged. And one of the tactics that I've seen over the last number of years, which has really troubled me, is the widespread use of impersonating email accounts, impersonating lawyers, or impersonating clients and then writing to lawyers. And it's designed to try to access information. And I'll just give you two examples of that, which I think just show how worrying this is as a trend. The first time I became aware of this at all as something that I was being subjected to was when I woke up one morning to literally about 30 messages from people saying, "Are you okay?" And it turned out that a very sophisticated spoof email had gone out to all of the KCs, or QCs as they then were, in my chambers, purporting to come from me. So, of course it means someone else in the world can spell my name, which is a start.
A real minority.
Yeah, exactly. But it was quite a sophisticated, well-written email. It sounded like it was written in my voice. It went to all of the QCs in my chambers, and it said, "Dear colleagues, because of my work on the Jimmy Lai case, I'm an enemy of the state in China. And I'm putting you all at risk by remaining in chambers with you. So I've taken the view that the only way I can protect you and your families is by resigning with immediate effect." And this was a well-written email. It was sent, we now know, the police told us those emails are quite often sent very early in the morning or very late in the evening. The reason being that when people then see the email on their iPhone or when they're slightly bleary-eyed when they wake up, they may not spot some oddities with the format, for example. And a number of people, these are sophisticated, silks who are experienced lawyers. One of them was a fraud lawyer and replied to it. And of course, then by replying, you get additional information and so on. So once I learned about that, I learned that this was actually being done in a very widespread way. So Shadow Keelan had, written to various ministers and various lawyers in other jurisdictions. And the other example I wanted to give, which shows you the real level of risk, is when a report came out a number of years ago by an NGO called Safeguard Defenders about shadow Chinese police stations, which were being used to target diaspora communities in a number of places worldwide. And the author of that report on that day got a fake email purporting to come from me, saying, "What a wonderful report, so important to highlight this issue of transnational repression, and may I offer you my services pro bono? I'd love to help." And again, this person who'd literally just written a report on transnational repression fell for the email and started replying, started providing information, and then became suspicious about 3 or 4 emails in when she was being asked for quite sensitive information which might put sources at risk. So she contacted me through another means and discovered this. Now, we know that this is very widespread, and it's not like the kind of tactics which, for example, Iran uses against journalists and human rights activists, where it has fake accounts on Instagram or fake accounts on Facebook, where you can at least see them. The problem here is the ones that we know about are only the tip of the iceberg. Now, that's a tactic which we now know is being widely used, and I'm concerned about it. And another very obvious thing, which perhaps the CLA could think about doing and professional organisations could think about doing, is warning people when these are tactics that are being used by certain countries. We need to warn people about them so that they're more alert.
Thanks. Some very salutary lessons. One of the key issues that I think we have to address is resource and how to help. And I'd like to invite Lord Justice James Dingemans, Judge of the Court of Appeal in London, to come to the stage. He's going to talk a bit about the International Law Book Facility, which can provide some resources should people need those. So, James.
Well, thank you, Mark, and I promise to be very brief. The International Law Books Facility supports the rule of law around the world by providing good textbooks to organisations that need it. It's in its 20th year. I was a trustee, I'm now a patron. Mark is still a trustee of the charity. And what it does is it gets books from universities that are closing down their law libraries because they've gone digital, from chambers in exactly the same position, from Law Society, and from individuals who make contributions of books. And over the 20 years, 95,000 books have been sent to 285 organizations in 62 countries. And these are good quality books in the sense that they are literally just out of edition. So what is the point of sending Clark and Lindsell around the world? Well, it gives access to information and enables lawyers to be better prepared and gives an equality of arms which is otherwise lacking. Today, those who've been handing around the microphones are from the University of Malta law students. We've got first-year law students, second-year law students, and third-year law students, and they thought they were coming to learn about law today, and they've learnt about some of the realities of the practice of law. But it's my great privilege to hand over some books to them as part of ILBF's support for students and organisations all around the world, all around the Commonwealth. Can I just ask you, on your conference app, on the homepage, to go down to featured exhibitors. You then have to go view all, and then you'll find the International Law Books Facility, the right spelling of it, and then just visit the website. If you want books for your jurisdiction, please do ask. We have, for example, in the Royal Courts of Justice, we're lucky enough to get a new White Book once a year, a new Archbold once a year. The old Archbolds, the old White Books don't go to waste. They go around the Commonwealth. But before I finish my 3 minutes, can I invite Michael Spiteri, who is of a third-year law student, but he is the president of the Malta Law Students Society. The books that LexisNexis were going to hand over are stuck in customs. Welcome to the real world of the International Law Books Facility. And so I have got 3 copies of Tom Bingham's The Rule of Law, which the Commonwealth Lawyers Association have very kindly given me to be a symbolic handover to Michael.